from Canada. She is an associate professor of law in the Bora Laskin Faculty of Law, which is Lakehead University in a place that sounds quite wonderful to me, Thunder Bay in Ontario in Canada. And I'm very much hoping that I will get to visit her there some point in the near future. And Frances did her articles at Cohen Hiley LLP in Ontario, working in family law, criminal law, personal injury, and tort law, amongst other things, and was called to the bar in 2003, where she practiced for 2 years. But she also obtained her JD and her LLM degrees in Ontario from the University of Western Ontario, and her PhD from Osgoode Hall Law School in York University in Toronto in 2009. Her graduate work focused on criminal law defences, including automatism, duress, and necessity. And she completed her Master of Laws degree at the University of Western Ontario before going on to do her PhD in Osgoode Hall, finishing in 2009. And Frances began teaching full-time in the University of Waterloo in 2007. And after 6 years there, she left to become a founding professor at the Bora Laskin Faculty of Law, Lakehead University in Ontario. And her interests in research and teaching there are focused on criminal law, particularly in defences, including automatism, duress, necessity, intoxication, and mental disorder. But she also teaches tort and criminal law, and looks at wrongful convictions, psychological coercion, and particularly violence against women and domestic violence. So very much a person who we are glad to have hosting Frances through the criminal law team, and very interested to hear her paper today at the intersection of discrediting, degradation and denigration, coercive control, parental alienation and institutional gaslighting. And Frances will speak for around 45-50 minutes or so, and then we'll open it up for discussion and questions afterwards. So I'm going to turn my camera off and just hand over to Frances for the next wee while, and then we'll come back for some discussion and questions afterwards. Thanks, Frances.
That's great. Hopefully everybody can hear me at this point. I'll make sure that I'm nice and close to my microphone so you'll all hear me. Thank you so much for having me here today. It's really a pleasure to get to do this, and to do the MacCormick Fellowship in particular has been really great. So my slides are not forwarding for some reason. Let me just stop that for 1 second and make sure everything is okay over here. Always technical issues. All right, let's go back here and I will share my screen. Hopefully that's going to work. Let's see. Yay, got it working. All right. As Sharon had said, I'm from Thunder Bay, Ontario, which most of the Scots I've met so far think Thunder Bay sounds completely made up, and I totally appreciate that. So I just wanted to start my talk today talking a little bit about where I am from, right on Lake Superior there in Ontario. We're very northern Ontario, extremely beautiful piece of the world. That's our Indigenous mound that they call Sleeping Giant, you see in that picture there. And here's our very pretty law school that was previously a high school, if you can believe that was a high school. So I do like to start all of my talks acknowledging the First Nations peoples whose land we occupy at Lakehead University, particularly the Anishinaabe people. Would like to always say that. And I just wanted to have another disclaimer. I will be referring a lot to women as the subject of violence in this presentation, acknowledging absolutely that this is violence that occurs against men as well, and parental alienation can happen against either parent. So I just wanted to make that disclaimer and a bit of a trigger warning, just to let you know that there is some material in this presentation that is a bit disturbing. So if anybody needs to leave, please feel free to do that. As Sharon said, I just had a little bit about myself. I have to update my bio. I was just promoted to full professor just a couple of months ago in July 2021. So I am now a full professor at Lakehead University. And I took a fairly traditional route in my legal education. But applying for this MacCormick fellowship was just really a privilege, but I applied for it in 2019. So, this is an area I've been looking at for a long time, and seeing time go by as we're going through COVID, my research has kind of continued to develop going through, and talking to Sharon about coercive control and looking at what Canada's going to do. What I want to do today is bring a bit of that Canadian perspective of where we are on coercive control and parental alienation. I'm going to try to get through as much as I can today. Like I was saying to some of you who joined early, I think I haven't lectured in so long that I think I could probably just talk for like 5 hours on everything. I have been on sabbatical, and before that we were teaching on Zoom, just like this. So it feels like a very long time since I've had an audience to talk about some of these issues, but have talked to several of you individually about a lot of these issues because I think they are so important. So I will be talking about the Canadian perspective on coercive control, looking at parental alienation, how that intersects with coercive control. I can never just pick one straightforward topic. This is always what's going on. I said to Andy before, it's never something nice and rosy and rainbows and unicorns. It's things like coercive control and parental alienation. So we'll talk a bit about that today. And I really want to get to some case examples, because I think that's what I can really add as a lawyer, as a trained lawyer, and as a Canadian lawyer. Some of these cases that we've seen going through the courts before and after some legislation changes, I think really helps highlight what's going on there. But just a touch about how I got into this field. I know people ask me how I possibly got into this field. In law school, I focused a lot on automatism. I'm a terrible sleepwalker and can really understand doing things that are completely beyond my control. Very hereditary. My dad's almost driven a car. And there was a very seminal case in Canada where somebody was acquitted on the grounds of sleepwalking for killing his father-in-law and severely injuring his mother-in-law. So that was something that caught my interest right away in law school. When I went on to do my master's, I looked a lot more at duress. I really loved the idea of being coerced, not just internally like automatism, but being coerced by somebody external to what you're doing. And this had led me on in my PhD that is very alternative, looking at brainwashing, a term that I tried to reclaim, not to very much success whatsoever, but looking at different organizations like the Manson family, Karla Homolka. I think there's some of the students from Andy's class here that I talked about that Canadian case to them as well, and the girl in the box case. So some absolute cases of sexual sadists, kind of the worst kind of situations. And again, spending 3 years thinking about that was a lot to withstand. But I've looked at everything from duress in contracts to a situation in Italy that was going on. And this really led me to this thought of, well, if other people can be coerced, what about one's children? What about coercion by a spouse? What about coercion within that family? And that's really what I've been looking at for the last year. I've always been interested in how people are controlled. In my PhD dissertation, I looked at prisoners of war, comparing them to the responses of domestic violence and women in those kinds of situations, and saw how similar this cycle of abuse was in prisoners of war and in battered women, and thinking, if prisoners of war are not expected to withstand some of this absolute emotional abuse that goes on, why aren't we recognizing it more in the Canadian law? So I really got into this area and wanted to clarify this concept for those who have never been in that type of coercive and controlling environment. And again, I've tried to share this with my students. Being a founding faculty member, we've now had 9 classes of students that have graduated, and seeing how they're practicing, how they're going out into the world to look at some of these issues. And I think I'll talk about more at the end of the presentation, but something I'm really focused on. Coercive control is so difficult to classify, so difficult to study because of these emotional and intellectual aspects to it. I've had students who have said, I absolutely would not find myself in that situation. I could never be in a domestic situation where I was controlled. And I think that's just absolutely not true. So many people have been caught up in these kinds of concepts. But it talks about our own agency and whether we can be controlled by a loved one. These are all issues that are very loaded situations to think about. And we're trying to figure out what to do in Canada as it stands right now. The criminal law system, as you may or may not know in Canada, is a federal system. So we have one criminal code for all the provinces in Canada. And this is a situation where when things need to change in the criminal law, it has to be done on a really broad scale. We do not have coercive control within our system, our criminal code at the present. And I've been looking at in the last year some of these changes to our family law system in Canada and what's happened. It's a very complicated structure to family law in Canada, that the provinces have their own legislation, as well as there being a Divorce Act, which is a federal piece of legislation then as well. So looking at coercive control and thinking, okay, how can this come into the law in Canada? And lots of you be very familiar with Evan Stark and his work on coercive control. And that really seems to be the term that's being used most often now, is coercive control, which again is one that is perhaps easier to explain to individuals. And there's a definition. I'm always looking for a great definition of what coercive control actually is. And Megan Stevens actually had a really great definition in her testimony before the House, trying to bring in legislation in Canada just earlier this year. And she said it's generally understood as a course of intimidating, degrading, and regulatory practices used by abusers to instill fear and threat into the everyday lives of their victims. Importantly, it's a highly gendered practice that often seeks to maintain or expand the gender-based privilege of a male partner. And again, understanding that I'm using gendered terms today, but when we look at some of the statistics when it comes to coercive control, women are the ones who are most often the ones that are subjected to this. These ideas about coercive control, what they are, not a new term whatsoever. I don't know if any of you have had the opportunity to watch the movie Gaslight. It's a 1944 film, so if you're looking for something exciting to do with your friends and family, please have a look at this movie. But this is where this colloquial term gaslighting came from, was this movie from 1944. So these are not new ideas by any stretch of the imagination, but looking at a situation where a husband was trying to drive his wife mad in this situation by the gas lights in the house. I don't know if you're familiar with the gas goes, when another light is turned on, the gas dims a bit, and it kept dimming in the room that the wife was in, but there was nobody else supposed to be in the house. So he was driving her mad, taking things and then finding them, trying to make her think that she was no longer in control of her life. And it's come to mean this manipulation by psychological means into questioning whether you know what is reality and what's not. Evan Stark actually did an online forum to do with this movie. They watched the movie as a whole, and then he talked about it. Really interesting if anybody's interested in that. And again, we see so much research. There's a great book that just came out, 2019 by Jess Hill called See What You Made Me Do, where she talks about a lot of these issues to do with coercive control in women, and made the fantastic point that even the most secure and strong-minded women can be reduced to someone utterly unrecognizable, even to herself. And it was very interesting to me talking to some domestic violence programs in Calgary and Alberta in Canada earlier in the year. They said one of the fastest growing segments of women who were finding themselves subjected to coercive control were affluent women who on paper look like they had everything in life. They have money, they have all these things, but nothing's in their own name. So they're unable to leave these bad relationships that they might be in, these controlling relationships. And I thought that was really interesting to think we think we know what a battered woman looks like. We think we know what somebody subject to coercive control is, but we really don't have any idea. It could be anyone. And again, this is something when we're looking at coercive control and these non-physical acts against somebody, when people, continually say, well, why would you just not leave a bad situation? Well, this coercive controlling element to domestic violence looks at abuse, from a different perspective, and why there are those kinds. I named my PhD dissertation Intangible Captivity. There seems to be this kind of captivity, even when there's not somebody like in duress with a gun to your head telling you to do something, why there is this prolonging of this abuse beyond separation, beyond all of these things. And Evan Stark is somebody who's really looked at this a lot and said, well, this kind of explains why it goes beyond just the time when somebody might be in that relationship to previous spouses, etc. And in the UK, it's been so interesting to see how much just even in social media is said about coercive control. We are not at that same place in Canada whatsoever. So I wanted to look at the UK and see what's happening here. And there seems to be a lot more understanding of what it is and how devastating that can be. I think that one of the big problems in looking at this issue are all these silos. I think we're very much like this in the legal system. This is what family law is. This is what criminal law is. And looking at me as somebody who's published mostly on criminal law during my entire career, people saying, well, why are you getting into a family law type of situation? I think we need to get outside of those silos and be able to talk about these issues, not just as a criminal issue, not just as a family issue, but looking at it across different kinds of law, let alone throughout different academic spheres as well. I think we need to be talking as lawyers to the social scientists, to social workers, to psychiatrists to figure out how we can come up with some kind of solution for people who are engaged in coercive control. And like I'll talk about later, parental alienation. Now, I'm sure you've all seen the statistics as it is in Canada. 1 in 5 homicides involves the murder of an intimate partner. This is such an issue that we need to pay attention to when we look that women are accounting of 8 of 10 victims of domestic violence, and what we can do to try to stop this situation. The statistics go on, but a third of Canadians self-reported abuse during childhood, and the WHO is saying as many as 1 in 3 women have experienced domestic violence. Again, shocking numbers of how many among us have experienced these things. 59% of female survivors of domestic violence report that their children heard or saw the violence. And this is something that I'm particularly interested in, the impact on the children of these relationships as well. So much of the time, it seems like they're forgotten in some of this material that we look at. And many of these threats occur post-separation, and looking at the children of these relationships, what happens in separation, what happens when custody agreements are being agreed to, what we need to do in those kinds of situations as well. And 1/4 of women report that the violent partner that they were with threatened to hurt or kidnap their children. And again, this goes back to so many of these different concepts that I had with these brainwashing experts, Louis Ocon being one of them, of this being intimate terrorism, of this being so much more than, simply something that was said to another person, and really has a lot to do with how that individual makes all of their life choices going forward. I woke up to this horrifying headline the other morning, just on November 12th, that homicide is the top cause of maternal death in the United States. Again, looking at statistics like that of how many women are subjected to domestic violence, and looking at coercive control, if that's something that we can focus on from the psychological side of what's going on. Now, when you look at the criminal code in Canada, and this is what I wanted to talk about today, because some of you might not be as familiar what's happening in Canada. When you go to the criminal code and decide, okay, what is somebody going to be charged with when they're engaging in interpersonal violence? There's about 20 some odd different sections of the criminal code that can be gone to for things from abandoning a child to sexual assault. But there is no one section on coercive control. And this is where the UK has been so ahead of us. England and Wales in 2015 introduced legislation, and in 2018, coming in 2019 in Scotland, is really the reason why I wanted to come here to look at, well, why do we have this hodgepodge of different sections of the criminal code in Canada when it seems like the UK is taking this much more seriously? We had a private members bill, Bill C-247, that was introduced in October of 2020. And waiting for my sabbatical to start, I was really heartened that maybe this was something in Canada that this was being introduced. It was a private member's bill, so it doesn't have the backing of the government, and went through that first reading in October of 2020. But even if you don't know much about the Canadian system, you can see it had a very long way to go to come into law, and did not do so. But this was a section that they had suggested come in at the time. And this was Randall Garrison was the private member in Canada who had introduced this legislation. And I don't know, this is very much a work in progress, trying to see what direction we should go in Canada. But everyone commits an offense who repeatedly or continuously engaged in controlling or coercive conduct towards a person with whom they are connected. This was extremely broad, who would come under this coercive control legislation in the criminal code. And they actually go on to talk about who this would involve, including members of the same household, whether the parties were married or not unmarried, whether they had agreed to marry. But under subsection 3 were also relatives in the situation. So again, this was an extremely broad section that was introduced last year, but we've had the end of our session ended in August 2021, and we had a federal election September of 2021. So this is something that is very much died on the table then as well. What we do have, and what I have been focusing on, okay, if the criminal law is not going to help out in this way to recognize that coercive control is an insidious thing that we have to deal with, we had a new section of the Divorce Act, and it actually came in March 1st, 2021. So it's only been enforced for a few months. And they talk about a new definition of family violence. And this is whether or not the conduct constitutes a criminal offense. So the Divorce Act only applies to married people, and it only applies in certain circumstances that are defined within the legislation. But I was really heartened to see for the first time in Canada that we'd had this kind of definition, talking about threats, talking about harassment and stalking, things like psychological abuse, financial abuse, looking at all those different elements. So I'm like, this is something coming in federal legislation that we can look as a Canadian nation and say, okay, how do we want to go forward with this? So I really wanted to focus on this Divorce Act and see what is actually happening there. And again, the government had used the rationale. It had actually been introduced in 2018, but didn't come into force until 2020 because of COVID. It was delayed some time as well. But they said it was particularly important in situations of custody that we look at the violence of a spouse. And for such a long time in Canada, as it was other places, we looked at this and said, well, just because somebody is violent towards their spouse doesn't mean they're going to be violent towards their child. And we've seen the statistics of how many children have seen this kind of violence, even if they were not themselves part of that violence. We're now recognizing that is child abuse. Seeing that kind of violence against one's parent is that kind of abuse. And we had this great definition that came in the Divorce Act. We had a bunch of the sections that were redone to kind of look at it in a new way. And one of the things I was really hoping would not be in this legislation was the subsection C of 16.3 that says, the court will look at each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse. Now, for somebody who's looked at domestic violence for as long as I have, this seems to be a very big red flag of how we're looking at one parent to support the other's relationship with their child. And as late as a 2021 case, just came out a few months ago as well, LB and PE, the court said even in the case that there was coercive and controlling behavior, and in that case there absolutely was, they stressed that if the mother facilitated contact and put the abuse aside, this was the preferential solution in this case. So again, in a situation where there is this coercive and controlling behavior, to expect somebody to put that aside and not talk about the abuse that they had experienced seems like a very unfair thing to put a woman, particularly, lots of them are women who go through this. Now, something I really want to write on is the evidence that we're looking at in coercive control. You can think in your own mind right now, like, how would you show evidence of somebody exerting psychological control over you, not letting you see your friends, not letting you go to the places that you want to go? All of these things of themselves are not criminal events. our system is very much set up in Canada to deal with episodic domestic violence situations. He hit you, this is where he hit you, there's a bruise, I can take a picture of that bruise and we can take it to court. Fantastic, we have everything we need. But knowing about coercive control, knowing about this ability to control somebody without having a gun to their head, this is a situation that we have to look at. Well, how would we possibly get evidence of that actually happening? And is it just always going to be the he said, she said, she said, she said kind of situation of coercive control that we're looking at to prove some of these allegations? And there seems to be a very love-hate relationship with evidence in these cases. And you can imagine a lot turns on credibility, and we deal with credibility every day, nowhere more so than in the criminal justice system, where you have somebody testify and decide whether they're credible or not. In these coercive and controlling situations, I think that the evidence is much more difficult. There's no great scientific test to tell whether you're a good parent or a bad person or a bad parent. There's nothing to say that, yes, you've absolutely suffered from domestic violence. We have a test that's going to show that. And trying to have this scientific element to what's going on, whether you are the victim of coercive control or not, it's a very difficult thing to prove in court. And I've been thinking a lot about this lately as well, of how are you going to do this? And how are people going to present in court? And so much of the time, it's the one who's the manipulative part of the relationship may come off way better in the courtroom. Those who are suffering from domestic violence, as Silberg and Dallum were saying in their article in 2019, if they've suffered from domestic violence, they may be extremely traumatized. They might have a trauma response, and they may not come to court in the way that we expect somebody to testify in court. And again, we don't have this scientific, you've been abused or you haven't been abused kind of thing. We're dealing with a lot of credibility. And I think we have to rethink whether that's the right thing to do in these situations. Now, we've talked about coercive control. I've added on top of this a discussion of parental alienation. And some of you might be familiar with that term. Some of you may not if you are more in the criminal law realm. But this was actually a concept that was recognized by two women. Ironically, it was two women who first wrote on this kind of concept in 1976, but it was not picked up mostly until the 1980s. And some of you probably have heard of Dr. Richard Gardner, who was somebody who said, okay, we have to look at this concept of somebody trying to alienate their child from the other parent. And Dr. Richard Gardner said, we can make this scientific. And again, thinking about evidence so much as I have been in the last year, thinking, oh, this sounds great. We have a scientific way to determine if somebody is alienating the child from the other parent. And this was something that Richard Gardner had coined in the 1980s, and he had actually called it parental alienation syndrome, PAS. And he said this was a syndrome that we had to recognize. And for many years, people have tried to get this within the DSM. It still is not within the DSM to recognize this concept, to say, absolutely, this exists and children can be turned against the other parent. And he said, this looks like a brainwashing kind of situation where you program a child to vilify and become hostile towards the other parent or the alienated parent in the situation. And I know lots of you have done work on this topic as well. And he was referring to a disturbance in which children are obsessed with the deprecation and criticism of the parent, denigration that is unjustified and or exaggerated. So when I first heard of this topic, I had heard of a case in Canada where one parent had wanted to alienate her son against his father. So she had said to the child, your father's a terrorist, he's going back to his home country, you can never talk to this person again, your father's a terrible person. So this is kind of the concept that we were talking about in the early days of parental alienation syndrome and Richard Gardner. Now, Richard Gardner took it a whole nother step, that's saying about 90% of the children who are engaged in custody litigation suffered from parental alienation syndrome. And again, this has been much questioned in today's research. To Richard Gardner's credit at different points, he had said that if there is actual parental abuse in a situation, there is no parental alienation syndrome. Again, this has kind of gone away over time, that lots of the cases that we're seeing in the Canadian court system have to do with alienation and with abuse in the same cases. His thought of where there is actual abuse, and again, him saying that there is justified abuse, perhaps is too simplistic. And his solution to this problem was to transfer the child to the home of the so-called hated parent. So he wanted a complete reversal of custody. And again, being somebody who really studies this kinds of concepts, how to control other people, this is something that I thought, okay, there can be something to this topic. There can be something there that's going on, but is it really that simple? Is this really so black and white? Is this the evidence that we're really looking for? Richard Gardner ended up writing multitudes on this area, and was very much known for pretty much this particular syndrome that he'd recognized. And he very much prided himself on being an expert in court. Anybody who knows about the American justice system knows that there's a Frye test for admissibility, and he had been able to get parental alienation recognized by American courts then as well. And he had testified all over the US. However, as more people tried to look into this topic, and many of you have written on this topic, they became extremely critical of this scientific basis of this research. And some great Canadian researchers, Michael Saney being one of them, had looked at these studies saying that there's inadequate assessment instruments, biased selection of subjects, lack of adequate comparison groups, inadequate statistical analyses, and circular reasoning in a lot of this work that Dr. Gardner had done at the beginning. So again, in our quest to say, okay, how can we prove this? We've almost shot ourselves in the foot at this point. Now, Dr. Gardner also is known for some of his work on pedophilia, and a lot of feminist researchers have felt that he has done a lot of misogynistic work then as well. And he actually died by suicide in 2003. Now, trying to learn more about Richard Gardner has been very difficult to do, as I've tried to do a deep dive into who he was. His obituary in the New York Times originally identified him as a professor of child psychiatry at the College of Physicians and Surgeons at Columbia, but they later did a correction to his obituary saying that he was actually an unpaid volunteer and not a professor of child psychiatry. So it's a very odd situation. And a lot of really great researchers like Joan Meyer had said that he was loosely related to Columbia Medical School, but had his own practice. So the numbers that he was basing a lot of his research on, which was mostly self-published, he had his own publishing company as well, which I'm like, ooh, that's a great idea. I should get myself my own publishing company. But a lot of this work was self-published on patients that he had before him, a very small group of patients that he saw. So looking at this, there's a huge tenuous basis that this is all built on, of what parental alienation is. But as I found over the last year, there are thousands of books, book chapters, articles, as was said by Jennifer Harman, across 35 countries and 6 continents. So this isn't just a little concept that caught on in North America or caught on in the UK. This is something we're seeing around the world right now. And one of the most interesting parts of this is Linda Nielsen, who has written a ton on this topic as well. She has said it's become more of a legal than a social science and child well-being concept in Canada. And this is what is really scaring me as well, of not having social scientists and researchers who are doing quantitative research on this topic say that this is something that the court should do. It's become recognized in Canada, it's within our process as well, and it's there to stay. Many have said there's nothing more polarizing in the family law field than domestic abuse and parental alienation. You know, I'm really glad to get that point a year into my research then as well, but it is so contentious, and researchers on both sides of the argument keep going back and forth. And it's a lot of name calling at times of saying, you're right, I'm wrong. and back and forth, vice versa, without getting to some of the basics of what we need to do here and to remember the children that are involved. And it's become extremely common in cases, and this is something I've learned over the last year, that where there are allegations of family violence and IPV and interpersonal violence, as we use the term a lot in Canada, there is a lot of return of an allegation of parental alienation. And what many of the researchers, Canadian researchers, American researchers, are saying that children will be harmed by judges applying these theories without fully understanding the nuances or limitations. There's so much to understand about parental alienation that we need to think about. And what was one of the most alarming things that I had learned over the last year are many lawyers in Canada and the US are actually telling their clients not to bring up any violence that has occurred against them, because there might be an allegation of parental alienation that is lobbed back on them. And this is going to be proof of their alienation by them raising any of the specter of interpersonal violence in their lives. Great movie. I don't know if anybody's seen this documentary. I actually went to a screening by Brunel University early this year about this film called What Doesn't Kill Me. And it's many women's stories of domestic violence within their relationships. And when they have brought up domestic violence within their custody cases, their spouse has brought up parental alienation and has neutralized that concept of domestic violence that they experienced. And they talk about going into women's shelters in the US and them saying, do not talk about the abuse that you suffered within your marriage. Do not talk about it. You're going to have your children taken away from you. And that was one of the first times I'd seen it in those stark terms of what was happening around the world when it comes to this. And we've had a lot of now qualitative studies that have looked at the numbers, and US courts, this US study that Joan Meyer had done said, the courts are significantly less likely to credit abuse claims when fathers invoke parental alienation. These correlations show that fathers' alienation claims are remarkably effective in undermining or discrediting a mother's allegations of child abuse. When a father claims a mother is alienating the children from him, a mother's abuse claim is 2.3 times more likely to be credited. So we have this quantitative research that's saying that this is something that is being used as this weapon within family law cases as well. And we've had some great work. Simon Lepere and Isabelle Cote from Canada have said they have absolutely seen this in the province of Quebec, where there are some serious concerns that in fact, going back with an allegation of parental alienation is completely neutralizing the domestic violence that happened within that relationship then as well. Now I'm just going to skip forward a little bit to this case of OM and SK. This is what I really wanted to talk about today. I have all these theories. You hear this, is parental alienation something real? Is it something that we need to take seriously? What we do know is it's being recognized by the courts. And I want to make sure that it's being done in a principled way by the courts if they're using this concept. So I found this case. This was before the Divorce Act legislation with that new definition of family violence came in Canada. But this is a 2020 case that had come out that kind of accentuates some of these elements that I've been talking about. And again, I give a trigger warning that there is child sexual abuse and interpersonal violence elements to this case. This was a 2020 case out of Ottawa. And again, it's easy for me to Monday morning quarterback this without seeing the parties, without seeing their testimony and what that judge had actually seen. It was actually a female judge, Madam Justice Bell, in this particular situation. OM was the father, SK was the mother, and they had a 4.5-year-old daughter named AM. Now, in this case, there have been minutes of settlement that were filed in this joint custody case that gave equal parenting time in May 2020. And the date becomes pretty important in this. This was a very high conflict case. The mother had alleged physical, psychological, and emotional abuse, coercive control against against him, in the situation, and physical and sexual abuse against their daughter AM. So she actually said that there was sexual abuse that the father had perpetrated against their daughter as well. So in June 2020, the mother sought primary custody. She had gone to Children Aid Society. She'd gone to the Ottawa police to say that there was child sexual abuse going on in this case. Now, this case comes before the court to decide what's going to happen with the custody of AM. And in a completely surprising move for me looking at the outside, the father was granted temporary custody. He was given custody in this case as of June in 2020. The father had signed this minutes of settlement on May 8th. But the mother said that on May 10th, before she had signed the minutes of settlement, she witnessed an action of sexual assault against her daughter in the bathtub by the father. She says she walked in on this. He panicked, pushed me to the wall, and later he threatened to kill me. The night he broke into my room at night with a knife and reminded me I have to finalize the documents, the minutes of settlement in this case, and leave. So she's alleging some very serious, not just coercive elements, but some with some actual physical elements of violence in this case. Because of this, she said, only because of the father threatening her, she signed the minutes of settlement on May 13th and agreed to shared custody because she felt this threat from the father. Not there all the time, not with a knife to her throat, but coerced in this way. She said that her estranged husband had threatened to kill her with this knife if she didn't go ahead with that. Now, interesting, the trial judge in this matter said, without a lot of explanation, this is a very detailed case that we're looking at. The judge in the case found that, quote, I do not believe SK. Her claim is simply not credible. Her behavior in the days following May 10th includes signing minutes of settlement that provide for equal parenting time is wholly inconsistent with her allegation that the father sexually abused the child on May 10th. There was no recognition of the trauma that this woman might have suffered from this kind of event. They found that this event just didn't exist and said that the only reasonable inference to be drawn from this evidence is that SK's counsel did not raise the allegation of sexual abuse because the incident did not occur. Again, those who have researched domestic violence know that people don't necessarily report that violence immediately. They might report it only when their children could be involved in a custody case. The court said it's nothing more than a bald allegation and is not supported by the evidence in the case that they were looking at. Now, we had this situation, a he said, she said situation with two completely different accounts of what had happened around that time period. There was no cross-examination of the affidavits that were submitted in this case, and there was limited third-party evidence and no expert. Again, looking at a situation where there's going to be these allegations of parental alienation, we have no experts here talking about this. Justice Bell said that it was required of her to make this decision on credibility, whether the mother was credible, whether the father was credible. And she said the conclusion made is that I do not find SK's evidence to be credible or reliable. I make this finding based on the internal inconsistencies in SK's evidence. And again, for those who have experienced domestic violence, the trauma might be there. They may not present as well in court as they may want to. There may be inconsistencies because of the trauma that they have suffered. There was no recognition of this whatsoever in this case. In fact, the mother was criticized for turning the child over for his custody visitations that he had. The implication being by the court, if your child really was abused, you wouldn't have handed them over. I can only imagine, and have read so many cases when a mother has refused to turn over their child in that situation, how much trouble they've got in and how much that has jeopardized their custody battle at that point. So it's kind of hard to think she should be criticized for turning the child over. The court said it's simply impossible to reconcile SK's behavior, particularly leaving the child alone with OM after the incident has occurred. She also made allegations of financial abuse going to this coercive and controlling behavior of the father, but didn't do this until much later on. Again, the court says, if you didn't do it in the first set of affidavits, if you didn't make those allegations from the beginning, we are not going to believe those claims that you might have. On the contrary, the court said that the father had no internal inconsistencies in his evidence. His evidence is detailed, his explanations are reasonable. I find his evidence to be credible and reliable, and I accept his version of events. There's very little that is given on the record that supports why this decision of credibility was found. Now, there is these child abuse allegations that the mother had as well. She actually had tapes of the child saying what kind of sexual abuse the child, who was only 4.5 years old, had experienced. But again, they used that evidence of the child being abused against the mother, saying this was evidence of parental alienation, that the mother was trying to pit her daughter against her father, and that was used against her in this way. Again, it seemed like all those allegations of domestic violence that had come were wiped out, as they said that this is just evidence of her alienating behavior. Now, the court used this other case, again, just an Ontario Superior Court of Justice case, to say that there was a 4-step test when it came to these cases in Ontario. If there was a prior positive relationship with the targeted parent, there is an absence of abuse. Again, there's lots of allegations of abuse, but that the mother is making in this case. 3, the alienating parent uses alienating strategies, and the child exhibits these recognized signs of a child who's been alienated in that situation. They go through the test, find that there was a positive relationship, that there was no allegations of abuse, which is very difficult to decide how that was thought of. And there was an absolute laundry list of all of the things the mother had done wrong in the situation, including not respecting the parenting time of the father. Some of those elements that we're looking at in the Divorce Act legislation too. Again, this was before those new changes had come in. They found that absolutely 1, 2, and 3 of the tests were upheld in this case, but they said in the 4th arm of the test that the court chose to use of those alienated child behaviors, the child wasn't exhibiting those behaviors. So absolutely, in my mind, seemed to fail the 4th arm of the test. However, the court found that the mother was on a campaign to deprive the child from having a relationship, and thus parental alienation by SK has been established. They said in this situation, it is absolutely essential to act very quickly in this situation, and they reversed custody, gave sole custody to the father in this case. Again, seems like a bit of a shocking result given what remains of the record, and as lawyers, we can only see what's in those judgments that we have to look at. No parental alienation experts were used in this. The 2017 case was used at a low level of the court. And there really didn't seem to be a lot of arguments of parental alienation on the part of the parties. It seemed like the judge had recognized, aha, I know exactly what this is. This is parental alienation, and I will act on that allegation. There didn't seem to be a lot of submissions by the parties about this, which I found fairly shocking then as well. And at one point, the mother's lawyer could not be at a hearing, and she ended up self-representing herself at key stages in the legislation. All right, I know I'm running out of time here, but I just wanted to compare this. Oh, it's important to note too that $40,000 in costs were ordered against the mother, who had very limited means, who said she couldn't work because of the ramifications of the abuse that she suffered in her marriage. The court showed no recognition of this whatsoever, said there was no history of family violence, and said no such finding has been made by the court, and ordered not only the $40,000 of the trial, but $1,200 of the motion on this matter ordered against her. When the mother said she did not have the means, the court said, well, you got an equalization payment in the divorce. Why don't you use that money? Again, I digress. All right. And again, the mother was very much disciplined by the court for her unorganized material, very critical of the mother at every element of this case. The one I want to compare that to is a UK case on an actual cult case that had happened in 2020. Fascinating case. If you have the chance to read this, absolutely do. This had happened around the same time as the Canadian case. And they were grappling with a judgment from a lower court whether or not to reverse custody in the situation. Now, the mother in this case was an active member of a cult, and in Australia, they had found this cult called Universal Medicine to be a cult. They had defined it as such by the courts in Australia, which was adopted in the UK, of this individual named Serge Behayon. And he had various elements that members of this religion had to uphold. He thought his daughter was Winston Churchill, I think still does. Very interesting cult that I had not heard of before. But in this case, we have two very loving parents. They had made up the name of Laura for the daughter in the situation. And they said they both were great parents. It just happened to be that the mother was a member of this particular cult called Universal Medicine. Now, the father started going to the authorities saying that his daughter had fatigue, had all of these other repercussions because there's an extremely limited diet in this particular religion that they were in. And they had seen that there was a lot of influence on the mother of her parenting because of these things. They couldn't have gluten. And the daughter started saying things like, "You're not loved, Daddy. Serge is love. You don't know anything, Daddy, and Serge knows everything. They won't reincarnate because they're eating gluten." So the daughter came to criticize the father, thinking he wasn't going to go to heaven because of this. And the father said, "I think this is a form of brainwashing. I think that she's being subjected to these things, and the child is being manipulated in this situation, even if it's not necessarily malicious." Again, both parents seem to absolutely love the children. This was going on. So the court in this case at the lower level said, we have to work very quickly in this situation. We can't allow a child to be alienated in this way. We have to do something very decisive action very quickly in these kinds of cases. So they said, in this case, the mother had made allegations against the father as well, that there was some sexual abuse in some way, very vague. It was an allegation of vaginitis that the child had, and the mother had blamed that on co-sleeping with the father in the same bed. They had social workers who were very much part of this, which I think is a big difference in this case rather than the Canadian case. And the social worker had, after working with the family for a long time, found that there was this risk of alienation that was going on. And mother had made coercive controlling allegations against the father here. Again, there's not much evidence of what that was from the record that we have. The lawyer for the mother was very firm that this was coercive control that was going on in the situation. The court found that, yes, the child's exposure to this cult is causing some harm in the situation, and we have confirmation from Australian courts that this is a cult. They said that the father's a very good parent, and besides this cult, the mother's a very good parent as well, but they kept the status quo of shared parenting in this case. They said, let's give the mother some time. If she can leave this cult, if she can stop giving the child these beliefs, maybe something can be done in this situation. This goes to the Court of Appeal. Again, the mother makes these allegations of co-sleeping with the father, but the lower court had said that there was no findings of any kind of sexual abuse by the father then as well. And the court actually at the appeal level got to the point of saying, this is inappropriate that you keep making these allegations with no proof that this had actually gone on in this situation. They said, this is a cult that you're part of. Please do something for your daughter to make this a better situation. They said, yes, there is this risk of alienation, no strategy for stopping that alienation by the mother as well. And again, we have to take decisive countermeasures to make sure she's not alienated against her father. But even at the appeal level, they said, let's postpone the decision. Let's give the mother some more time to leave this cult. Maybe she's working on this. Maybe she can do better. By the time we get to July of 2020, again, the social worker is saying, I think the mother's just saying what she thinks we want to hear, that she hasn't actually left that cult as well. Even though she's saying she's left Universal Medicine, we don't really believe that she has. And the court is absolutely not accepting the coercive control. We've gone through this before. We found no evidence that there was coercive control. And this, again, they reversed the custody in this case after a period of no contact with the mother. Now, again, after they had ordered this, the mother actually took the child to her house and begged the judge to reconsider in the situation, reversing custody, but he refused to do that in this situation. So where do we get to in all this? Looking at these cases, one case in Canada seemed to act quite quickly, and you can totally understand the thought that parental alienation is going to lead a child to be alienated, that we should do this as quickly as we possibly can. Both cases, it was the mother who lost custody. Both cases, the custody was ultimately given to the father, but very different cases in different ways. And I respect more how the UK court had treated the parties, giving them those extra chances. I think, again, the child has to be the one that's considered in both of these cases as well. And again, we only have cases with the facts that survive. Well, what I'm afraid is of institutional gaslighting. We tell women, we tell parents, you have to come forward with that evidence that there was abuse in the past so we can help the child, we can help you. We don't want to trivialize what's happened to you at all. But when the one parent brings this up and the other parent responds to this with a parental alienation allegation, we're seeing something that's kind of disturbing, that suddenly the court is forgetting about that domestic violence that came in the past at some points. And each court is different. I think it's extremely scary that a judge is being able to decide, do I believe in parental alienation? Do I not believe in alienation? And there's a really great article written by Leslie Lang and said, mothers who had been talking about what judges had actually said to them in the US. One mother said, the judge actually threatened to take the child off me and that I would have supervised care if he saw me in court again with such rubbish allegations of domestic violence. The judge did not want to know. She had another mother who said, I've been traumatized by him, meaning the father, and even violence. And now I'm traumatized by dealing with people who just can't, that cannot acknowledge the fact that we have been abused and have no education about how this has affected us. Another mother described herself as being silenced, and her children were silenced as well. I'm afraid that this is happening within the system, and I'm really worried about what that ramification can be. And this is why I was using those terms of discrediting, degradation, and denigration. There's the 3 Ds of brainwashing in the 70s that were dependency, debility, and dread. And I'm looking at this the same way of not believing a lot of people that they have been coercively controlled in the past, shaming them that they're not putting that aside so that they can parent that child together, forgetting what went on, and trying to vilify them in one way, like bringing that evidence of sexual abuse and saying that they didn't want to hear it. Peter Jaffe, who's an amazing academic in Canada, said that despite all this we're doing to try to encourage people to come forward, he calls these 4 painful stages. Not being believed, then being believed but having the violence minimized, then being told that the violence is an adult issue and not relevant for the children, and finally recognition of the impact of the violence but being told to get over it and become a co-parent and put the past behind them. This is what I'm afraid is happening. Very much a work in progress for me to try to determine what's happening. I want to talk to more lawyers in Canada about whether this is what they're seeing at the intersection of these 2 things. One last thought I will leave you with, this concept of upstreaming. Nick Child, who's on the call today, hi Nick, had brought to my attention this book called Upstreaming by Dan Heath. And in that book, if you can read it, it's an absolutely great book then as well. But they had talked about a situation of domestic violence where a woman was looking at the pictures of a woman who'd been killed by her spouse. And what she noticed by the autopsy pictures was that this woman was wearing a cast. And she thought, okay, this woman has had injuries in the past and she's gone to the hospital. She's gone somewhere to seek that medical treatment. We could have done something then. I've kind of taken this perspective and saying, can lawyers do something more? Can we have mandatory screening for domestic violence for all lawyers in Canada? I took some courses on mediation and arbitration of family matters and found out that they have a 20-hour screening for domestic violence course that you have to take, which was so great with role-playing, understanding coercive control, talking to experts on the issue. I'm like, every lawyer should have to do this. And this is something that I can do do. I can work those incidents, talking about coercive control, not just in the criminal law that I teach, but in tort law. It could be worked into any course in law school, and I'm really passionate about trying to make that happen. And we want to protect those people who might come to lawyers as their first point of reference to say, I need help. Instead of just giving them a pamphlet and sending them on their way and saying we don't want to take their case, can lawyers do more? We're not trained medical professionals. That's not our job. But can we make sure that they do get to those right places before the terrible thing happens at the end of the day? And having judges just decide that they know what parental alienation and coercive control is without adequate training, there always needs to be that training for judges. But as I've been told by so many people, it's changing their actions, not just changing their attitudes on these different things. I'll leave you with this quote that in this one report that I read, they said in this one study they were looking at 100% of mothers indicated they experienced family violence and 100% of fathers denied the violence. Fathers alleged alienation, among other things, in 71.4% of the cases. This is the kind of situation that we're dealing with, that we have to do a better job of figuring out exactly what is going on here. And we need to be more, stop being arsonists rather than firefighters, I think, in this entire situation. So I will stop talking for questions. Sorry, I am over my time there, but there's my contact information if anybody wants to talk about these issues privately then as well. Thanks, Sharon.
Thanks, Frances. That was really great. You covered a huge amount of ground in that relatively short period of time, so thank you for that. And I can see